And you've been listening to the live audio from inside the U.S. Supreme Court, where justices have been hearing a case on the abortion pill mifepristone and so much more. Joining us now, NBC's Yamiche Alcindor outside the court. Also with us this morning, Lisa Rubin, MSNBC legal correspondent, Christy Greenberg, former federal prosecutor, Catherine Christian, former assistant Manhattan district attorney, and Neil Katyal, former acting solicitor general. All three are MSNBC legal analysts. So, Catherine, this has been fascinating to be able to sit there and listen to what's been going on in the court. What are your takeaways from it?
Well, I think of what Justice Jackson's her question. Do courts have specialized scientific knowledge about pharmaceuticals? And the first thing I said was no. And I think that was a very telling question. We were discussing beforehand, if you were winning a bet about which justices would bring up the Comstock Act, if you said Alito and Thomas, you win. So those are my immediate takeaways.
And so, Neil, give us a broader picture of what was the discussion today, what were the supposed issues, and some other ones that were brought up, including the Comstock Act.
Sure. So first of all, just by way of disclosure, I am unabashedly against this lawsuit to stop women from being able to have mifepristone. My law partner, Jess Ellsworth, just argued the case, and I thought that the oral argument went really poorly for the challengers to this drug. Sometimes it's really hard to tell after an oral argument who's going to win, and to be sure, anything can happen, and I've sure seen it, but this one didn't appear close. The backdrop to this argument is it's the first Supreme Court argument since they overturned Roe versus Wade and the Dobbs decision roughly 2 years ago. And now abortion is up to individual states, and this drug is being used in every state to try and give women some measure of reproductive justice. There were two issues in the case. One sounds technical, but it's really important. It's the doctrine of legal standing. Who can come into court to challenge a government action? The other was the merits. Is this drug, and the way the FDA has expanded its access, is that impermissible because it creates side effects and things like that? I think the outcome was really quite clear, having listened to this argument now, that the justices, a wide variety of them, don't believe that there's legal standing to have this case. They basically called Erin Hawley, the lawyer for these religious doctors, they called her theory probabilistic. And I think her case dissolved in questions that were asked by Justice Gorsuch and others about how if there are federal conscience protections that work so that these doctors don't have to perform something that they disagree with, then why in the world are you here? Why are you able to come in and make a federal case out of this? I didn't hear an answer to that. And so as a result, I counted every justice except Justice Alito as being really quite skeptical about this legal theory of standing. If they don't have legal standing, then the case goes away. You don't even get to the question of whether the FDA acted appropriately or not. And right now, it seems like there are certainly 5 justices, maybe as many as 8, that reject the Hawley view of legal standing. And so it seemed like a pretty easy case. I was surprised, honestly, that this oral argument has ended so early. In a big abortion case like this, you'd expect the argument to go at least 2 hours, if not more. But the court seemed like they had their minds made up from the minute that they walked into the courtroom today.
And Neil, talk to us a little bit about that difference and distinction, the issue of standing in this case, but also there was the issue brought up of equitable remedy versus universal injunction, and that as a legal dogma is different.
Yeah, and you saw Ms. Perloger, the Solicitor General, the federal government's top lawyer, getting at this toward the end of her argument, and also questions by Justice Gorsuch. Basically, what both of them were saying is, look, you've got this possible speculative harm to doctors in which, some of their patients may take this drug. Those patients may have side effects. Those side effects may lead them to go to the emergency room. these individual doctors that have the consciences against abortion might be the doctors on call. They might then have to do something they don't want to do if the federal conscience protections don't work or something like that. And so what Gorsuch was saying, as well as the Solicitor General, was, boy, that's a really speculative chain of causation. And as a result of that chain of causation, you want to be able to come into a federal court and stop the entire nation from getting access to these drugs. That can't possibly be right. And that's where the Solicitor General ended her argument. It was her very last words. I thought it was an incredibly powerful way to end. And, I think that's something that appeals to both the left and right of the court, which is when you have something that's speculative, you can't just have a nationwide injunction to stop access to the drug when the FDA has duly authorized access in these ways to that drug.
Lisa, what were your main takeaways?
Well, Jose, in the recent Colorado case on the 14th Amendment, you saw a concurrence in the judgment from the 3 liberal justices that really took issue with those in the majority saying they decided more than they had to. And today, I was prepared for an argument that might have gone down similar paths, deciding more than they had to. In fact, I predicted to Catherine that we would hear lots of argument about the Comstock Act, which is a very old statute that prohibits essentially sending abortifacients through the mail. And that's been a project of the right to try and make this whole case somehow about the Comstock Act. It's really not about whether or not the FDA had authority to allow expanded access to mifepristone, but they're trying to sort of raise this Trojan horse of actually nobody should be allowed to send abortion pills through the mail at all. But today, what we saw was not a court that wanted to decide anything more than they had to. In fact, as Neil was just discussing, Justice Gorsuch was very precise and very clear in the fact that he doesn't like the idea of nationwide injunctions generally if you can offer more circumscribed, particularized relief to the plaintiffs who have been injured. So even if you were to suppose here that several or even one of the doctors that Aaron Hawley represented today has in fact been injured in a way that is constitutionally recognizable, what Justice Gorsuch was saying to her is, why should that mean that we, as Neil was just alluding to, prohibit nationwide access to mifepristone as expanded by the FDA when there is a narrower path here? Justice Roberts also emphasized that. And I think you're seeing a court that has been soundly criticized in recent weeks, both with respect to the Colorado case, but harkening back to last year with respect to the Dobbs decision. They've been criticized again and again for going further than they needed to. Today, they were prepared to basically go no further than they needed to and stop this case at its very root. If there's no standing, there's no case. But even if there is standing for a couple of people, why should that mandate some sort of nationwide injunction when the doctors impacted here could have much smaller, tailored relief to their injuries?
So, Yamiche, what's the scene been like outside the court?
Outside of this court, you've really heard people really interacting and having a very big rally here for people that are in favor of abortion rights access. There was a rally that was planned here, and there are hundreds and hundreds of people walking around with signs that are saying, don't keep your hands off my body and keep access to this pill. We have, though, also interviewed some people who are anti-abortion voices, and they've been saying that this pill kills people. They've been making claims that this is really an unsafe pill and that it should not have had, it just should not have the access that it has right now, and it should not be as accessible as it is right now. But I also want to say that in regards to what's going on here, of course, because you can hear all of the music, there's also, I think, this feeling when I was listening to the oral arguments, this idea that the justices were being put in this situation where they were in some ways asking scientific questions. You heard Amy Coney Barrett saying, well, does there really have to be an ultrasound before this pill is being administered? You also heard these justices really trying to narrow in and talk about the idea of whether or not there was a precise case, a precise argument that the anti-abortion lawyer could make when it came specifically to the harm that it would be causing. Neil said it, but the Solicitor General was really very clear in her language, talking about the profound harm that they believe would happen if the FDA loses this case. And that's what you've really heard, the echoing of that argument, that last part of what we heard when the oral arguments were wrapping. That's what you're also hearing outside here, that there are women out here in signs, protesters out here saying that this would really be harmful for women across this nation if this access to this pill were to be taken away.
And Christy, the DOJ points out that the group of doctors trying to restrict this pill are doing so on religious and moral grounds. They do not prescribe mifepristone, and the FDA's approval of the drug does not require them to do so. So do they even have standing to bring this case to the Supreme Court?
I think it was pretty clear from these oral arguments that they do not. There were 7 declarations from various doctors that were submitted in this lawsuit. Out of the 7, not one of them can say, here is the care that I provided. Here is the objection that I clearly stated to providing that care. And here is where I was forced over my objection to provide that care. None of these declarations say that. Not one of these doctors is able to say that they were forced to perform an abortion against their objection. And so that's really the injury. You have to be able to show under law that there is an existing or an imminent, about to happen injury that is clearly identifiable. And they have not done that. And I think that really ends the inquiry. I think the other thing that was really important, and a number of the justices mentioned this, under federal law, if any of the doctors have an objection to performing an abortion, they don't have to perform one. The federal law allows them to have that objection and to step away, and employers cannot force them to do so over their objection. So Justice Jackson talked about that quite a lot and said, the remedy that you're asking for already exists in federal law. So this sweeping remedy that you want to restrict access to this abortion pill really does not fit any, attenuated injury that you may be able to articulate.
Hey everyone, MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.